I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Tarrant County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East San Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business.
Pause real quick here. So looks like what we have going on here is maybe a probable cause hearing, or it could even just be an initial appearance from jail court. Usually they don't go too much into the facts in initial appearance though, so I'm guessing that this is a probable cause hearing. At the beginning of every case, you have to find probable cause to have the person charged, right? To charge the defendant with a crime. That can be done in a couple different ways. A lot of people are familiar with the first way, and that's a grand jury. You put the case in front of a grand jury, the prosecutor gets to tell the grand jury about the facts of the case, or at least the facts as they see them. They'll call a witness, and the grand jury will decide, is there enough probable cause to charge this person? The other way, I think, is what we have going on here. This is a probable cause hearing where the judge will hear from, usually a police officer will testify. It sounds like the prosecutor is just reading the probable cause statement to the court to state what the probable cause is. In these situations, unlike a grand jury, the defendants or the defense counsel can actually play defense, right? They can actually cross-examine the officer if he or she is testifying. So there is some defense that they can play there versus a grand jury where the defense counsel is generally not even in the room.